Hi, this is the Business Guy. So what's better, an asset protection trust or prenuptial agreement? We're going to answer that question, and then I'm going to give you some examples as to which one works better in the real world. I'm the CEO of Asset Protection Planners. We have attorneys on staff and are the nation's largest asset protection firm. Now, you can set up an asset protection trust yourself without the intervention of your future spouse. An experienced professional creates the trust, you put your assets inside it, and established properly and legally, we have seen the proper trust very effectively protect assets from divorce. With a prenuptial agreement, on the other hand, you must hire an attorney who represents only you. Your future spouse must hire a separate attorney that represents only him or her. The two attorneys hammer out the terms. Your fiance's attorney fights for more, yours fights for less, and then after battling, the two parties usually come to an agreement. You both sign, and then if there's a divorce, opposing counsel can challenge the validity of the prenuptial agreement and poke holes in it, rendering it ineffective and leaving your assets exposed, as you'll see in a moment. And you've got to hear the story I'm about to tell you about one of our staff attorneys who got divorced before he came to work for us. What happened to him in a divorce will blow your mind. Now, a trust, especially an offshore trust, where our offshore trustee law firm is outside of the jurisdiction of your local courts, is very difficult to challenge. In fact, we have never seen one of our clients lose money in a divorce case for whom we have established an offshore asset protection trust. Now, we've helped establish both trusts and prenuptial agreements. However, from our decades of experience, we have seen the trust as the most effective option for most people. And the most effective option for keeping up to date right away when new videos like this one come out is by clicking the subscribe button below and notification bell. I'd also appreciate it if you could please click the like button below so YouTube promotes this video. Protecting yourself from divorce. You're about to marry the love of your life. Talking about trusts and prenuptial agreements right now isn't exactly romantic, but it's smart. They say marriage is when a man and woman become one, but the fighting starts when they try to decide which one. Your assets, especially high-value assets, may be at risk down the line. Divorce may be the last thing on your minds, but the American Psychological Association cites that 40 to 50% of first marriages in the United States end up in divorce. The rate for subsequent marriages is even higher. Even if you and your partner never divorce, there are also outside lawsuits, as well as the future death of a spouse to consider. Without trusts, prenuptial agreements, or an asset protection plan, you're vulnerable to the whims of a judge. Now here's the story I promised. Before he came on board, one of our employees, a Florida barred attorney, went through a nasty divorce. The judge wanted to give the wife 100% of all the assets. The judge figured that since he was an attorney, he could make it all back again. What about 50-50, he asked. After all, that's what the law says. Our employee then appealed the decision. He won the appeal. He then returned back to the original judge. The judge asked, "What would you like me to do for you?" "Abide by the decision of the Court of Appeals," was his reply. The judge said, "Nope. She still gets 100%. This happens in courtrooms every day of the week. Results-oriented judges often cast the law aside and rule as they see fit. That's why an asset protection trust, especially a Cook Islands Trust in the South Pacific or a Nevis Trust in the Caribbean, are the strongest asset protection tools we employ. In fact, we have established more of them than anybody on the planet. Our international law firm/trustee can step in to protect you when needed, and being international, they're not subject to the court orders of a rogue judge, such as the one we just talked about. See our video on Cook Islands Trusts for more detail. In that light, how helpful is a trust or a prenup? How do you know which strategy is right for you? In this video, we'll define a trust and a prenuptial agreement and then compare them side by side. But don't put your wives side by side if you decide to marry two of them at once. That's called bigamy, and the penalty for that is 2 mother-in-laws. Defining terms. Before we explore the differences between a trust and a prenuptial agreement, we'll define those terms first. Now, there are 2 main types of trusts: revocable and irrevocable trusts. Both trusts are an important part of estate planning. These trusts manage or protect assets as the trust grantor or owner ages. The trust verbiage determines how assets are managed and distributed to beneficiaries after death. Investopedia defines an irrevocable trust as a fiduciary agreement that has terms that cannot be modified or amended or terminated. Often the grantor, the one who formed the trust, such as you, or the grantor's named beneficiaries, can request that the trustee make certain changes. Conversely, a revocable trust is one in which the grantor can alter or cancel provisions included in the trust. Now, this allows for flexibility and income for the grantors who earn money from the trust during his or her lifetime. An irrevocable trust, properly structured, has an added benefit of protection from creditors. But a revocable trust allows the grantor to cancel the trust and reclaim the property at any time. Thus, the grantor's creditors can generally do the same. Once a revocable trust grantor dies, however, the trust becomes irrevocable. Okay, now a prenuptial agreement. A prenuptial agreement is a contract that two people create before entering into marriage. Most often, this agreement focuses on outlining the terms associated with dividing up financial assets and responsibilities at the end of the marriage. Couples decide to get a prenuptial agreement or a prenup for a variety of reasons. Professional asset protection planners, such as those in our organization, often create such trusts to protect property as part of a larger estate plan. Benefits of a trust. Setting up a trust before marriage can be one of the keys to keeping assets separate from your partner. There are several benefits to putting your high-value assets into a trust. When an experienced organization, such as ours, drafts the terms and conditions of the trust carefully, it can be very effective asset protection. It can even protect your assets in the case of legal action against your spouse. The law usually considers any assets placed into a trust as separate property, as long as you created it before marriage. And this is especially important for business owners if you own real estate. Putting property into a trust gives ownership of the property to the trust instead of you, so a future ex-spouse has no claim on that property. The law does not consider assets you place into a discretionary trust as belonging to the beneficiary when it comes to alimony. A discretionary trust is one you have set up for the benefit of one or more beneficiaries. The laws vary by state, but most states uphold that one cannot enforce a claim for alimony against a trust that one created prior to marriage. Trust benefits even when you stay married. Even if you remain with your partner, a trust is a great asset protection tool. Lawsuits from your business or an automobile accident could create a huge financial strain if you aren't prepared. The best way to protect yourself is to make yourself the smallest financial target possible. Trusts take away the ownership of assets, and the less that you personally own, the less there is for a lawsuit to take from you. With the right kind of asset protection trust, you can have access to the use of the assets as needed within the protective guidelines. Therefore, a trust can prevent a lot of financial problems no matter what comes your way. I mean, as Henny Youngman said, the secret of a happy marriage remains a secret. Benefits of a prenuptial agreement. People often associate a prenuptial agreement to protect assets with celebrities and the extremely wealthy. But they have many more uses. People of all ages and many different situations can benefit from a prenup. ARAG Legal explains that if you have a significant premarital estate, it is a good idea to make sure that your spouse will only get as much as you wish in the event of divorce or death. Now, this is especially true if you want to protect the inheritance of your children from a previous relationship. A prenup can also protect income and assets acquired during your marriage. Without setting the terms at the beginning of a marriage, you may end up paying unexpected support or alimony to your ex-spouse. Now, what you put into a prenuptial agreement is dependent on what's important to you. The requirements by state vary on a prenup, but many of them require that each party have their own attorney present. Doing so helps prevent a court from declaring the prenuptial agreement invalid. Now, a prenuptial agreement is a binding contract, but you are able to mutually amend it later in the form of a post-nuptial agreement if your circumstances change. Prenuptial agreements are also good ways to protect some of your intangible assets. This includes, but is not necessarily limited to, intellectual property and business ventures. So which one is better? In our years of experience, the answer for most people is an asset protection trust. To be clear, this is not just any trust. It is a trust that you structure specifically with asset protection in mind. Both a trust and a prenuptial agreement have their benefits, but which one is right for you? And the answer depends on your situation. If you have significant assets to protect, based on decades in the asset protection field, I have seen that the trust is most likely the best choice. One of the key differences between these types of asset protection strategies is how many parties they involve. Using a trust to protect assets in divorce is something that you can do alone, whereas a prenuptial agreement requires the agreement and signature of both parties in the marriage. It's also important to note, if you create a prenuptial agreement, it needs to be done right. An agreement that isn't written correctly can leave room for an attorney to find loopholes. Anything not in writing clearly can be contested in a divorce court. Like one wife who wanted more affection asked, Our new neighbor always kisses his wife when he leaves for work. Why don't you do that? The husband said, how can I? I don't even know her. Prenuptial agreement weaknesses. The bottom line is, a prenuptial agreement makes you plan your divorce before you get married. If there is a great way to throw water on the fire of a romance, this is it. If there's a great way to get your future spouse's mind to focus on marriage failure before you tie the knot, this is it. He or she will leave to hire a separate attorney. Their attorney will go over all the legalities of the divorce and will negotiate to get as much of your assets as possible should the marriage fail. After divorce, opposing counsel can poke holes in the validity of the agreement, push for more, and invoke any of a series of theories of legal liability. A proper trust, on the other hand, protects assets regardless of the validity of a prenuptial agreement. Kick it up a notch and set up the Asset Protection Trust and Trust Bank account offshore. When you do this, the offshore trust takes the assets out of the jurisdiction of your local courts. For decades, we have established offshore trusts, and we have not seen one of our clients lose money through a judgment or divorce proceeding. No matter which strategy you use, it's a good idea to have an open and honest conversation with your partner about finances and assets before marriage. Once you've created a plan, you should also keep their stipulations in mind. Some of your actions after the marriage begins may void the conditions of the prenuptial agreement, but it should not have any bearing on the validity of your offshore asset protection trust. If it is a domestic trust, however, adding joint assets to a personal trust could lead to the courts to deem those assets as marital property. Alternatively, the judge could invalidate the trust altogether. Not so with a properly structured offshore trust. But I'm already married. Marriage is like deleting all of the apps on your phone except for one. And if you're already married, is it too late to protect yourself in a future divorce? The answer is no. There are still many ways of protecting your assets after marriage. The most important thing to focus on is keeping everything you want separate, truly separate. For any property that's only in your name, you should create or keep your own separate bank account to pay for any expenses. Using joint funds to pay on that property could lead it to being considered joint property down the road. And any joint funds used to pay for real estate or mortgages often turns that property into marital property. Keep track of all your premarital documentation. Account statements from banks, brokerage, or retirement accounts from the previous month can also help establish their value. Keep any copies of wills or trusts that show an inheritance along with your account statements. If you had your business or other hard-to-value property appraised before marriage, these documents can be important to show their value. Continue to keep good records for all separate accounts. Another option is a postnup or postnuptial agreement, like we touched on briefly. This agreement is very similar to a prenup, except that it is created after a couple is already married. The contract is especially helpful if a couple wants to divide things up differently than the laws of their state would otherwise dictate. This written agreement is a more secure way to lay out who owns what than any verbal promises or understandings between couples. Postnup weaknesses. The postnuptial agreement has the same or more weaknesses as the prenup. If the marriage is already on shaky ground, forget it. The attorney you must hire for your spouse to put together such an agreement will likely eat you alive. You can set up an asset protection trust, on the other hand, without the involvement from your spouse. Naturally, co-owned property, such as real estate, will require mutual agreement. Another huge problem with postnups is that they are usually brought up after the love is already on the rocks. In such a combative environment, the guard is already up and the willingness to cooperate is low. So at that point, establishing an offshore asset protection trust where you place your assets beyond the reach of the courts may be one of the only effective options. Postnups are tough when the light at the end of the tunnel is the divorce train coming right at you. Final steps before the big day. One husband asked his wife, "Why do you keep reading our marriage license over and over again?" His wife replied, "I'm looking for an expiration date." Whether you choose a trust, a prenuptial agreement, or something else, make sure that you're doing it right. Feel free to contact our experienced attorneys and consultants today. We'll help you better understand your options and ensure that you have the proper legal tools in place. Planning for a wedding is exciting and time-consuming, but don't use it as an excuse to put off protecting yourself and your assets. By doing the financial work up front, you'll be prepared for whatever life has in store, regardless of what happens to your relationship. Please click like, subscribe, and share this video with others. Thanks for watching. This is The Business Guy.